Hi, welcome to Case Law Minutes. My name is Joel Persaud. I'm a student at Osgoode Hall Law School. Today we'll be looking at the Supreme Court case Office of the Children's Lawyer and Balev, which came out in 2018. Just a quick disclaimer, this presentation is for general legal information only. If you need advice on a legal case, we strongly encourage you to consult a lawyer. Before I begin, it is important to understand why this case is significant. This case is important because the Supreme Court of Canada provided much needed guidance that helps judges to decide a child's place of habitual residence in accordance with Article 3 of the Hague Convention. Among other things, the Supreme Court's guidance helps judges to properly interpret the Hague Convention so that children are properly protected from abduction and parents' custody rights are enforced. So let's take a look at the facts of this case. In this case, the parents, husband and wife, married in Ontario in 2000 and moved to Germany in 2001. While in Germany, the parents had two children. The parents subsequently separated. In Germany, the children struggled in school, and so the husband agreed to let the wife take the children to Canada for 16 months in hopes of seeing improvement in their performance at school. After 16 months of living in Canada, the father asked the court to order the children's return to Germany. The wife did not want the children to return. This resulted in a legal dispute between the husband and wife. Despite all the litigation, the children returned to Germany in 2016. Although the children were returned to Germany, the German courts gave the wife sole custody of the children. Thus, the wife and children were allowed to return to Canada in 2017. What's interesting about this case is that throughout this legal dispute in Canada, the Canadian courts were tasked with ensuring the children lived in their place of habitual residence, pursuant to Article 3 of the Hague Convention. However, the Canadian courts could not collectively agree on how to best determine the children's habitual residence. So although the custody dispute was resolved between the husband and wife in Germany, and there was no need to pursue the matter further, the Supreme Court felt they should provide clarification on the issue so that courts could properly determine a child's place of habitual residence in the future. So there were two issues that were dealt with by the Supreme Court in Balev. The first issue, which is the main issue, is this. How should an application judge approach the determination of a child's habitual residence under Article 3 of the Hague Convention? The second issue deals with exceptions. How should an application judge determine whether to permit an exception for the return of a wrongfully removed or retained child based on that child's objection to returning? Ultimately, the court held that a hybrid model should be adopted when determining a child's habitual residence. The court also said that when it comes to exceptions, judges should adopt a facts-based and common-sense approach to determining whether an exception should be made based on the child's objection to being returned. So the first question you might ask is this: what does the court mean by a hybrid model? What is this hybrid model? And secondly, what is this facts-based and common sense approach that the Supreme Court wants judges to use when considering exceptions? In other words, if a child says that he or she does not want to move, how is a judge supposed to deal with that? Well, let's start with the first question dealing with the hybrid model, and then we can address the second question dealing with exceptions. The Supreme Court considered three models to determine the habitual residence of children. One model suggested we should focus on the intention of the parents in determining habitual residence. The second model suggested we should focus on the child and how well the child is connected to his or her environment. The Supreme Court argued for a third model that occupies a middle ground between the two models I just mentioned. This is called the hybrid model. The hybrid model states that courts should look at all relevant considerations to determine a child's habitual residence. This includes the child's connection to their country and the intention of the parents. However, there is no definitive list of factors. Courts must look at the child's complete situation and they cannot allow one factor to dominate the analysis. So why adopt this new hybrid model? Why not use the other models? The Supreme Court provides two reasons. First, the hybrid model brings Canada into conformity with other signatories to the Hague Convention. Other countries such as the UK and New Zealand have adopted this hybrid model. Secondly, the hybrid model best complies with the text, structure, and purpose of the Hague Convention. The Court found that the hybrid approach best ensures the return of children under the Hague Convention. It does this by deterring parents from abducting children while also encouraging a speedy resolution of custody disputes and protecting children from the harmful effects of wrongful removal from their homes. Okay, so that still leaves us with our second question. What is this facts-based and common sense approach that the Supreme Court wants judges to use when considering exceptions? In other words, if a judge finds that a child was wrongly removed from his or her home, how would the judge know whether to make an exception for the child when the child objects to being moved? It should be noted that Article 13 of the Hague Convention allows judges to make exceptions in cases where a child objects to being moved. In order to figure out how to make those exceptions, judges must decide if the child has attained sufficient age and maturity to provide evidence. Judges can assess maturity by drawing inferences based on the child's demeanor, circumstances, and testimony. Judges also have discretion to call for expert evidence if they think it necessary. It is important to note, however, that expert evidence cannot be used to delay proceedings. If you're looking to read this case, you can read it on CanLII. Feel free to use the link provided. And that's the end of this video. My name is Joel Persaud. Thanks so much for watching Case Law Minutes.